Hello and welcome to the third video in your legal research course. We're going to learn how to read and understand legislation for a research task by tackling one particular piece of legislation, the Indian Penal Code. To help us do that, we're going to rely on a set of facts to guide our research. Jiten, who was Mr. Das's driver, was taking the family dog, a Rottweiler, for a walk. During this walk, they encountered another man, Srinath, walking a much smaller dog, a Shih Tzu breed. As they approached each other, Srinath asked Jiten to move away from his path. This led to an argument. The situation snowballed and Srinath walked towards Jiten with a stick and hit him quite hard on the head. The hospital where Jiten was taken diagnosed his injuries and recorded that his skull was fractured and that he had suffered a mild concussion. Now let's assume that we have carefully gone through the steps involved in analyzing the facts. Let's also assume that after that, we did some background reading from some textbooks on criminal law and found out that the principal legislation governing these facts would be the Indian Penal Code. So let's turn our attention to the Indian Penal Code. This is a copy of the criminal manual brought out by Universal Publishers. I'm using this edition that was published earlier this year to be sure that it has incorporated any recent amendments and changes to the law. It contains the text of the Indian Penal Code. The first step when you encounter a piece of legislation, especially one that you're not familiar with, is to look at the table of contents. This is a pretty long statute, so the table of contents itself is pretty long. This publication has nearly 20 pages of the table of contents alone. But make sure that you take some time and go through the table of contents. The first few sections are like most statutes of a formal nature. They will name the statute, define the extent of its operation, and so on. Soon after, you will see the definitions section that define the various terms that are used in the statute. The Indian Penal Code has a long list of definitions that keep going well into the 50s. And if you continue going through the IPC, once you reach the 120s, you will start seeing the different offences, that is, acts that have been declared as crimes. This is why it's a good idea to go through the entire table of contents of any piece of legislation you are looking at, especially one that you are unfamiliar with. It will help you understand the overall scheme and structure of that statute. You will start getting familiar with what is dealt with in which part of the statute. And as you go through the table of contents in this fashion, you will notice the titles of a few sections that at first glance seem to apply to the facts that you are concerned with. One of the first ones you will notice is section 319, titled Hurt. Let's turn to the page and see what that section has to say. Whoever causes bodily pain, disease, or infirmity to any person is said to cause hurt. Well, that seems to apply to our facts, doesn't it? Because the man caused bodily pain to the driver. So that seems to fit. Let's keep going to see if there is another section or sections that fit better. Section 320 talks of grievous hurt. To understand what's the difference between hurt and grievous hurt, let's turn to the text of the section. If you read it, you will see that only specific types of hurt are designated as grievous, and the seventh such type is fracture or dislocation of a bone or tooth. That's interesting because it also seems to fit our purpose. We know that the driver suffered a fractured skull. It would seem, therefore, that at least one of his injuries fits within this definition of grievous hurt. So section 320 is also relevant for our research into these facts. Let's continue browsing the table of contents to see if we find something more appropriate. Section 322 is entitled Voluntarily Causing Grievous Hurt. Let's have a closer look at it. You may have to read through it a couple of times before you completely understand it. Trust me, you have to get used to reading and making sense of such convoluted text. Most legislation, at least in India, is drafted in this manner. This style is also quite common in older statutes in the English-speaking world. Basically, what it's saying is that the requirements for the offence described in Section 322, that is, the offence of voluntarily causing grievous hurt, are A, that someone voluntarily causes hurt, B, that person intended to cause grievous hurt or knew that it would cause grievous hurt, and C, the hurt that they caused is grievous hurt. You can also see that there's an explanation. This is a feature you will find in the IPC and some of the other older statutes. You can consider this explanation for some further understanding of this section. So the part of the explanation that applies to our case is the first one. A person is not said to cause grievous hurt voluntarily except when he both causes grievous hurt and intends or knows himself to be likely to cause grievous hurt. So at a later stage, when you analyze this research, you will have to ask yourself, did this man both A, cause grievous hurt, and B, intend or knew himself to be likely to cause grievous hurt? To answer the first question, yes. We've already seen how hitting on the head with the stick caused a skull fracture, which falls within the definition of grievous hurt. But to answer the second one, we perhaps have to infer his intention from his actions. At this early stage of our research, we can say that it's easy to infer that if he struck someone on the head with a stick with a fair degree of force, he either intended to cause that level of hurt or knew that it was likely that he was going to cause that level of hurt. So we've examined these sections, and at this stage, we strongly believe that Section 322 embodies the offence that we can charge these men with in this case. But that's not the end of it. When you're reading any statute, and this goes for any area of law, you need to check the rest of the legislation. In fact, you need to check the rest of the law on the area to make sure that you are not missing anything. So let's go back to the table of contents. Here's another interesting one. Section 338, causing grievous hurt by act endangering life or personal safety of others. Well, that sounds very similar to our case. So let's have a closer look. This section, you will learn, is meant for rash and negligent acts that endanger human life. So an act such as throwing bricks off the roof while building a house without caring where it will land may be more appropriate here. Not such a case as ours, where one person struck another with a stick. So let's keep going. What about Section 336? Act endangering life or personal safety of others. Again, this provision does not seem to deal with acts done with the intention to cause harm, and so may not be suitable for the facts that we are dealing with. Further along, we see sections 349 and 350, which relate to force and criminal force. Criminal force is the intentional use of force on any person to commit an offence. That looks like it may apply to our set of facts. And then we have assault in section 351. If you look closer, you will see that this doesn't actually apply when you make physical contact with someone. It's more like a threat or something that makes someone scared that you're about to use force towards that person. So perhaps if the man had just threatened the driver with the stick and the driver was afraid that this person was about to hit him with the stick, well, then that might have been an assault. But isn't our case actually more serious than this? Section 352, which is about punishment for assault or criminal force otherwise than on grave provocation, will help us better understand whether Section 350, that is criminal force, applies to our set of facts. The maximum punishment for criminal force is imprisonment for 3 months and a 500 rupee fine. If you think about the extent of the driver's injuries, you may feel that the offence is a more serious one. Let's compare this with the punishment for the offence in Section 322, which is found in Section 325. The maximum punishment is imprisonment for 7 years and a fine. So this is clearly a much more serious offence. And in most cases where you're looking at what kind of charges apply, you will always prefer the most serious offence. And this is an example of how we need to look at the priorities of an area of law to identify the most applicable section. So the field of criminal law is interested in affixing responsibility for crime and punishing it appropriately. A comparative analysis of the different punishments prescribed for different offences has helped us arrive at the most appropriate provision to apply to our set of facts. We have reviewed the other applicable sections to make sure that there is nothing better suited. Now that we have gone through all the provisions and identified that Section 322 is the most appropriate one for our set of facts, it's the best fit with our facts among all the sections we have read. Now we need to go back and read it again, more carefully this time. The objective of this second reading of Section 322 is to fully understand it. You especially need to check whether there are any other sections that you need to read in order to fully understand Section 322. Some of the terms that are explained in other sections of the IPC are hurt and grievous hurt. Remember, we had already decided that the seventh designation of grievous hurt, fracture or dislocation of a bone or tooth, fit at least one of the injuries that the driver suffered, that is the skull fracture. So we know that we fit within the definition of grievous hurt. What about the term voluntarily? Where can we find out exactly what it means? Now, in any case where there is a term that needs a definition, you have to first look within the same statute to see if the term is defined there. Remember when we browsed through the table of contents, we had come across a bunch of definitions. If you go back and check again, you will see that the term voluntarily is defined in Section 39. Again, that definition seems to fit the case that we have before us based on what we can infer from that man's actions. Now you may ask, what if there is a term that is not defined in the statute? Well, of course, while the first place you need to look for a definition is the statute itself, you can certainly turn to case law to better understand a statutory provision. In the next unit of this course, where you will learn how to read and use case law properly, we will illustrate why just reading the bare text of a statute may not be enough. Sometimes you need the assistance of case law. In this case at least, we do not need the assistance of case law to fully understand Section 322. Anyway, this completes our analysis of the statutory provision that is most applicable to our set of facts. Another associated section is the penalty provision, which, as we have already seen, is Section 325. It prescribes punishment of up to 7 years imprisonment and a fine. The final thing that you need to look at while reading a statute is to look for exceptions and other carve-outs that affect the operation of the applicable section. In the case of criminal law, they will turn up in the form of defenses to the main provision. So make sure that you read those provisions that affect the operation of the main provision. So in this video, we have learned the main steps that we need to take in order to read and understand a piece of legislation for legal research tasks. To recap, you have to start by identifying the provisions of the statute that are the best fit for the facts. Then, identify any other provisions that will help you understand this provision. Determine whether you need to read any cases to better understand this provision. And finally, check whether there are any exceptions or defenses that affect the operation of the main provision. If you take these main steps with a clear understanding of the facts, then you are well on your way to tackling any piece of legislation. Thank you for watching.